Thank you, Your Honor. I'm going to focus on remaining allegations, which fall under two broad titles. The state on the page 7 of its second amended petition.
Page what was that?
Page 7, Your Honor. The state turns to two other provisions under the statute. Under the incompetency definition, there's an A, B, and C. A is gross ignorance of official duties. B is gross carelessness in the discharge of those duties. And C is what Mr. Alexander just discussed, which is the issue of physical and mental defect. We've covered C. I want to cover A and B, which are the other two grounds that the state has requested citation to be issued on. First and foremost, Your Honor, I think it's important to note two legal principles that I think have to govern the court in evaluating this. And that is, what does the word gross mean in each of these definitions? And I think the court has to note that it is tied to the issues of duties. In the case of DeAndre versus State, the court there said that the word gross is analogous here to the gross negligence standard we use in common civil law. That is, it's not enough to show that someone did something merely wrong or made a mistake or anything of that nature, but it's much more elevated than that. It's an issue of intent. It's an issue of the mens rea of the individual. In civil cases, when we talk about gross negligence, we discuss that somebody had a conscious awareness of an extreme degree of risk, but a reckless disregard of that risk. And I think when we look at each of these, which we're going to go through each of the allegations contained in the state's petition here, you will see that what they are arguing here is not something that will rise to the level of a gross carelessness or a gross ignorance. Frankly, I don't think it arises even to a simple level of carelessness or a simple level of ignorance. But it certainly doesn't rise to the level of gross. And if you look at them each singularly, you will see that none of them reach this level. The second is that both provisions there of incompetency is tied to the issue of duties. Gross ignorance of the official duties of the office of the district attorney. Gross carelessness in the discharge of those duties. And here, the focus has to be on what are the duties of district attorneys. And that's an issue of law, Your Honor. The district attorney's office, what their duties are to prosecute cases in the name of the state of Texas. That's in the Code of Criminal Procedure. Each attorney, district attorney, shall represent the state in all criminal cases. That's one of the duties. The government code provides additional duties, such as the criminal district attorney shall collect the fees and commissions provided by similar services rendered by district or county attorneys. They shall report at times to the commissioner's office. These are the duties of a district attorney. And nowhere in the state's petition is there a reference to any actual duty of the district attorney's office that was ignored or not met. It doesn't exist anywhere in that petition. And I think it's important here, Your Honor, I'm going to show the court two, may I approach, Your Honor?
Yes.
Two quotations I think animate this discussion. One comes from the last time the Supreme Court of Texas addressed the ouster statute, N. Ray Wolf. And it discusses, but individual citizens have no private interest in ouster distinguishable from the public as a whole. The remedy of ouster is one which belongs to the state in its sovereign capacity to protect the interests of the people as a whole and guard the public welfare. That's the purpose of this statute, protect the public welfare. Make sure the district attorney is performing the duties necessary to protect the public. Is there any evidence anywhere in this petition? Is there an allegation anywhere in this petition that the public was exposed to any danger, that the duties were not met? The second quote I think that needs to animate this discussion comes from Reyna versus State. Before a public official will be removed from office for failure to perform a duty, exactly what the allegations are here, the law must have plainly enjoined such a duty upon him or her. So with those guides, let's turn to what the actual allegations are. On page 7, the first one right out of the bat. the defendant, the district attorney, proved to be grossly ignorant of the legal requirements that regulate the use and disposition of certain restricted funds entrusted to her office. Now, what is the factual basis for that claim? We have two affidavits of individuals who speak to this allegation. The first is Cindy Stormer, which was with the original petition, and the second is Jennifer Bolito, who's filed an affidavit in support of the state's petition just this Tuesday, I believe. And Your Honor, in the affidavit of Ms. Bolito, I think, gives us some very good guidance as to how we should evaluate this claim that D.A. Hawk was grossly ignorant of the laws and regulations governing these funds. This is the affidavit of Jennifer Bolito, and she notes in her affidavit on page 2. Ms. Bolito had the position of Administrative Chief of Finance. That's also what Ms. Stormer had as well. One of my first duties as Administrative Chief was to review all of the funds overseen by the District Attorney's Office, the funds discussed on page 7, to determine the balance in each account and to determine what was or was not a proper expenditure of the money in each account. It is Jennifer Bolito's duty, just as it was Cindy Stormer's duty, and just as it's Mr. Costello's duty now. It's the duty of that position to determine what was and what is not a proper expenditure of the money in each account. It is not a duty of the district attorney elected and sworn in on January 1st to just know, to arrive on the scene with a perfect knowledge as to how each of these accounts should be operated. There are people in her office that do that for her. Indeed, Ms. Bolito said it is her duty to do it. She goes further. The district attorney's office has a number of bank accounts holding funds from various sources, and each account has different statutes that regulate how those funds can and cannot be used. So each of them have different statutes. Ms. Hawk was concerned about these accounts because there had been some accusations from her campaign and the media that the funds were not being properly used by the previous administration. So D.A. Hawk, far from wanting to misuse the funds, was concerned about their proper use and charged Ms. Bolito to go and review that. And here, I think it's important, I reviewed the funds and researched the legal issues surrounding the expenditures from these accounts. Ms. Bolito, who, as her affidavit shows, is a highly qualified person whose qualifications are actually very similar to Judge Hawk's. She was in the district attorney's office, and she was a judge as well, and she arrived in January of 2015 to perform this task, just like Judge Hawk. She had to go do legal research to figure this stuff out. She did not arrive in January with the perfect working understanding of all these funds and how they should be used. It was a task that she was charged with, and she had to go research herself. Now, turning back to the state's petition, let's review the language here. After assuming the office, the defendant proved to be grossly ignorant of the legal requirements that regulate the use of those funds. Again, was it her duty? No, it was not. But assuming, for purposes of the argument that the state advances, she should have known. Can this court, is this court going to endorse the argument that somehow D.A. Hawk asked the person charged with those duties questions, that is an indication she's grossly ignorant of her duties in a way that jeopardizes the public? Because that is the tie for all of these arguments. As the Supreme Court noted in Wolf, the issue is this necessary to protect the public welfare? Is the elected official not performing their duties in a way that jeopardizes the public welfare? Is D.A. Hawk asking a question about how an account should be used, is that a gross ignorance of a legal requirement that she had a duty to know, and that her asking questions jeopardize the public? Of course not. The state continues. The defendant frequently made or attempted to make improper and unauthorized use of such funds to pay for office equipment and furnishings, to pay fees and salaries charged by consultants, and to pay for personal political activities such as associated with the celebration of Martin Luther King Day. Let's break that down. Made or attempted to make improper and unauthorized use of funds. What is the evidentiary basis for that? The evidentiary basis in the affidavits is the contention that the DA asked questions, requested that funds be used in certain ways, and was told you cannot do that by the person whose job it was to go do legal research and figure that answer out. Is that a duty of the district attorney's office for which he is grossly ignorant and it jeopardizes the public welfare? No, it is not. The questions were asked and the answer was given, no, you cannot do that. That's not grounds for ouster. There is no gross, in the term of gross negligence, ignorance, or carelessness as evidenced by that.
Let me ask you how much more time do you want to use?
Your Honor, 15 minutes?
I just want to be sure we leave plenty of time for the other side. Go ahead.
Thank you, Your Honor. The same as with the fees and the salaries, Your Honor. Questions were asked, answers were given, you cannot do that. That is how the office operates. We submitted the affidavit of the individual who currently has that office, Mr. Kendall Costello. He currently has the position that Ms. Stormer had and Judge Bolito had. And in that affidavit, he states, just as Jennifer Bolito, it's his job to provide advice and guidance regarding those purchases, and he has never seen anything inappropriate, and Judge Hawk has always followed his advice despite questioning. This last one here, to pay for personal political activities. And this is sort of a mountain out of a molehill. This involves the purchase of candy for a parade.
Candy for what?
A parade. A little more context is provided in an affidavit provided to the court last night by Mr. Glenn Fitzmartin, who explained this whole candy situation. It turns out the district attorney's office, over the years, has participated as a matter of community outreach in a Martin Luther King Day parade to get out there and be present in the community. The accusation as contained in these pleadings is that someone said there should be candy purchased, and Judge Hawk said buy the candy, and whether or not county funds should be used to buy that candy is somehow an issue apparently that they believe satisfies ouster. But what we know is that funds were used by individuals to purchase a small amount of candy, and that D.A. Hawk had nothing to do with that. The decision to purchase the candy and to try to participate in this parade, as Mr. Glenn Fitzmartin said, it was his decision making. It had nothing to do with D.A. Hawk. These decisions, whether or not you can second guess them, do not rise to the gross level that is necessary here. Going further, they have a whole paragraph dedicated to the fact that the defendant proved to be ignorant of the fact, on page 8, that because she's a public servant, she's not required to pay the state's attorney occupation tax. Again, simply, is that a duty that the DA has? The qualifications for a duty is to be a licensed attorney and win an election. Knowledge, perfect knowledge of the occupational tax code is not one of those. There are people who decide that for. Trying to take that bit of information and transmute that into an indication that someone is just grossly unaware of the law and they have to be discharged is simply inconsistent with the purposes of this statute. The same contention goes to the issue, and I'll speed up based on the court's questioning, with respect to these staff salaries. The same arguments. Questions were asked, decisions were made based on the advice of the individuals present. It's not an indication of gross ignorance or carelessness because somebody says, I disagree with the DA's question or the DA's purpose in making those requests. So I want to turn to the next one is mismanagement. The other two grounds for carelessness are this mismanagement of employees, which Mr. Alexander addressed, and the gross carelessness by leaving. Again, we have to be informed by the words here of gross and duty, and nowhere in the context of this allegation or this petition, is there any indication that there was ever a statutory duty not met? So in summary, Judge, Your Honor, I would ask the court to think about this with the seriousness which the state admits is necessary. This is a very serious issue. There are matters both of the law and public policy here. Are we going to permit employees who are discharged to just file an ouster petition within a month of their discharge, make a bunch of allegations, and attack someone's mental health? Is that going to be something we're going to greenlight going forward? And I submit to Your Honor that that would be an idea that is both dangerous and unproductive and inconsistent with the law. There's no indication that the duties of the Office of the District Attorney have ever been impaired. There's no indications that the duties of the District Attorney's Office have ever not been met. The only real contention here is we have disagreements from employees with the DA, none of which rise to ouster, and that DA Hawk bravely sought treatment for a mental condition and is doing just fine. And the court ought not allow this to continue further and ought not send a message to both Judge Hawk and to everyone who thinks about running for office in the future. If you have a mental condition, be prepared. Because if you're elected, someone can file a petition and dig into your mental health background and try to oust you because of something that a doctor wrote on your medical records years before. The condition suffered by DA Hawk does not rise to the level of ouster because it pre-existed, and it is not simply a defect that prevents her performance in office. So we would ask the court to send a strong message by refusing to issue citation. Thank you.
Ms. Wilson.
I think I'm going to be pretty brief. I think what we've heard from the defense is a remarkable closing argument for a jury trial. A lot of facts have been argued here before the court, but that's not the purpose of this hearing today, to weigh the underlying merits of the petition. We believe the state has made sufficient allegations to meet the threshold for the court to issue citation. A couple of responses to some things that the defense said I'd like to touch on, however. I think it's remarkably disingenuous to liken mental illness to a physical defect such as a broken leg. If it is a job requirement of someone to run a relay race, then a broken leg is going to disqualify him from that job. The district attorney, especially the district attorney in a very large metropolitan jurisdiction of Dallas County, that job is largely a mental job. And if someone has a mental defect that renders them unfit for that job, they should be removed from office. Furthermore, present behavior is no defense to past conduct, Your Honor. And the greatest observation I'd like to make to the court is we've heard and seen lots of affidavits, sworn affidavits, from lots of people. We have not yet received a sworn affidavit from Ms. Hawk. We've not yet received a sworn affidavit from Mary Woodley. We have not yet received a sworn affidavit from a medical provider. We do not know what Ms. Hawk's mental or physical condition was at the time of the allegations that are the basis of the state's petition. And I think that's profound at this point in time, Your Honor. This narrative, and that's what it is a carefully crafted narrative that she's had mental illness since she was in the 7th grade. Frankly, that's all simply, the basis for that are well-crafted interviews that she engaged in as part of a public relations campaign only in response to mounting public questions about her conduct and, frankly, her whereabouts. None of those statements are sworn. She at no point in time has bothered to swear to the veracity of any of her claims of her mental health. And I'm reminded fundamentally of the objection we all learned as our first-year law students in mock trial. When the other side would make a motion for directed verdict, the narrative we learned was, Your Honor, I think sufficient evidence has been submitted such that reasonable minds could differ. We have allegations that I believe meet the requirements of the petition. Some of the affidavits that were filed late yesterday by the defense, frankly, even corroborate that there were concerns about the state of her mental well-being. You know, on November 3rd, 2015, that morning, the Dallas County Commissioner's Court appointed me to take over this case. At almost the exact hour that court was meeting, I was unconscious on an operating table right here in the city of Dallas. because I had a physical defect that needed surgical repair. Yet that afternoon, I was running my office. Thanks to the wonders of modern technology, while I was recovering in my bed, I was able to communicate with my office. I was able to direct courses of action in response to things that were happening in my office. So I think it's absurd that in the year 2015, we can suggest that someone can just disappear for 11 weeks from an office as important as the Dallas County District Attorney, and that's okay. Your Honor, there's simply, at this point in time, there has been no evidence at any point in time submitted of what Ms. Hawk's mental condition was at the time of these allegations. There are suggestions that she may have been abusing drugs, legal or illegal drugs, yet she has simply crafted a narrative that she was suffering from depression, and I submit to the court that's nothing but a PR campaign, and that's not sufficient for the court to make a ruling. We ask that you issue the citation.
Let me ask your side of the case a question or two.
Yes, Your Honor.
You mentioned, you said present behavior is not a defense to past misconduct. But Mr. Alexander said that in effect, you remove for incompetence or unfitness now. And so I want to raise the question of, and understandably, because the 5 affidavits that you have submitted are from people who worked there and then were fired in early 2015, and they're not there now to testify that now. But other people are. And so if someone has, done things early on in 2015, gotten treatment, and is not still doing those things, and things are running smoothly, which is what the evidence, the other affidavits say, why should that case proceed?
Well, again, Your Honor, that assumes facts not in evidence, fundamentally. But first and foremost, the statute doesn't contemplate that. And the simple fact of the matter is, the statute simply says, if there is misconduct, if there is gross carelessness, etc., at any point in time, then that is sufficient for removal. Simply put, the statute doesn't say if this happens, but then everything's okay later on, it's okay. There's not a King's X provision in the statute. It's like if a train derails, Your Honor. A train goes down the track and it derails, it causes a big mess. At some point in time, the railroad comes along and picks up the train and it goes on down the track and it's fine, but there's still a big mess that gets left behind. And that doesn't absolve what took place in the past, and the statute provides no out on that basis. Just like any sort of, I don't want to analogize this to a criminal prosecution, but because criminal conduct can be part of the removal statute, I don't think it's an inappropriate analogy. If someone commits a criminal act, but then by the time the case comes to trial, they're a choir boy, that doesn't excuse the criminal act, and that's the best analogy, the simplest.
You used the word absolve, and so let's talk about it. Is this a case about punishment for misconduct, or is it a case about being sure that someone who holds an office to which the voters elected her should continue in that office, and do you not focus on the situation now as opposed to punishment?
I think it's the latter, potentially the former, and that relates to this forgiveness doctrine that was touched on just briefly by the defense. It's been, the argument is being made in practical sense that, well, she had this condition before she got elected. She's had it since the 7th grade, therefore it's all hunky-dory. We don't know that, Judge, and certainly the public did not know that before she got elected, and so I think, again, that's a disingenuous argument to make. But if it's about making sure that someone who is mentally fit is in office, we don't have enough evidence to determine that at this point in time.
Yes, go ahead. Why don't you remember what you want to say, and then if you want to have it, that's fine. Hypothetical. Let's say there's a county treasurer elected by the voters and put into that office. And he shows up for work in the first few months of the job, he cannot get the books balanced, cannot get payroll paid on time. the money that comes in, receipts, doesn't get them accounted for and routed to the right account, just doesn't know how to do it. But learns how to do it. Gets a mentor, goes to some education and so forth. But the first few months of the job, it wasn't getting done right. But now it is. Now, that's not exactly our situation, but just for thinking it through, should that person be removed a year into the office for inability to do the job? I'm not saying this all, facts of this case, but hypothetically. Should the treasurer that I'm hypothesizing be removed for inability to do the job the first few months of his or her career, when now they're doing okay? That's the question.
I think we had that treasurer in Ellis County one time. I think the answer to that question is potentially. If someone files a petition making allegations of gross carelessness, and there's an opportunity to explore those allegations, I think the best and most honest answer is potentially, depending on what the facts and the evidence may show in that particular case.
Yes.
Your Honor, Mark Haney again on behalf of the realtor.
Mr. Walker, I'll call on you.
Well, respectfully, Your Honor, I would like to interpose an objection, and the reason why is simply this, Your Honor. We've had the kind of realignment of parties, and I think it's clear the state is the party moving. And earlier, Mr. Haney spoke, and he was starting to make arguments that may have existed in Cindy Stormer's original application, but are not in the state's amended application.
If Mr. Wilson is content for him to speak on his side, he can do it. You okay with it?
That's fine.
Go ahead.
Your Honor, I just want to bring to the court's attention, I think what the court's asking for, is there current evidence, is there current information that's being out there about how Ms. Stormer, Ms. Hawks operating her office? And what we have been receiving in our office since the time of the filing of the pleading are anonymous calls for people alleged to be in the office of the district attorney claiming she remains not present on the job, and they're continuing to have issues and questions about her fitness for the job. They're afraid to be known because they're afraid they'll be terminated. But I think they don't have the opportunity to explore that evidence under the cloak of the protections of the lawsuit.
Yeah, let me follow that up. I think probably one reason you can have a seat, because I'll make that clear, I'll next question. I think one of the reasons why we have provisions like this removal and gatekeepers, for lack of a better term, like you have to be here for state, and the judge from the outside has to sign off on it. And one reason for that is that to allow a trial and the pretrial discovery and diversion from work and so forth. I mean, money cost is another thing, but to allow that is not a cost-free process. It's a cost-heavy process in terms of the human impact on it. And I think probably the lying behind this law and the gatekeeping aspects of it is a recognition that to go through the process and achieve perfect truth and interview people and so forth exacts heavy costs, and the whole end goal is to take from office someone that the voters put there. So those costs, it seems to me, have to be thought about. And so let's talk about that. And I think that's raised by your question. Let us go forward and we can interview people, go through discovery and that kind of thing. But that's not a cost-free process.
I agree wholeheartedly, Your
Honor. Now, you wanted to say something in response, I think, Mr. Walker.
No, Your Honor, I just wanted to make sure we were focusing on the petition at hand as opposed to extraneous allegations and arguments that we had no evidence of.
Your Honor, as an aside, one thing I forgot about, you mentioned earlier, if you are interested in hearing the corollary about Tarrant County, Mr. Wright was a 27-year employee of that office who didn't retire when the new administration came in. If you're interested in hearing that, I just wanted to make you aware of that.
I simply asked if there's a comparison between Dallas and Tarrant County. You've got people who were fired by the newly elected DA. If those are truly comparable situations. I was just wanting to know whether in Tarrant County people that Sharon Wilson had brought in herself, if she fired them or if she fired people who were already there. Is it the latter?
Well, I think it was a matter of,
You brought it up.
exactly. And what I'm saying is, to your honor, it was a matter of ill-advised argument on my part. Okay? They got us diverted onto a subject that need not be at hand. So let's erase Tarrant County, and then we don't have to go into an explanation.
I don't want to erase this question. He asked. Several people chose to resign before she took over. Some back in.
Several who were already there?
Several who were there.
Previous administration.
Previous administration chose to resign before she came in. Some chose to retire before, at the end of Joe Shannon's term. I was one of those people. She asked me to stay for a month and help out, so I chose to stay. She brought in, some people were, she believed, I suspect, I don't know this, I wasn't part of the team, but some people were told they weren't going to be in charge of things they had been in charge of, and that in a year or so their salary might be reduced. There was one person that I'm familiar with that she brought in as her team that was fired.
So it's a mixed, okay.
And other than that, I don't know of people. There are people who left after she, but none of them raised allegations.
Appreciate it. Okay.
Your Honor,
Yes.
just since I was charged on behalf of the state to speak to the specifics of the petition, I would like to recall us to the issue at hand. Under the provisions of section 87.015C of this statute, there is a requirement for a petition that must set forth the grounds alleged for the removal of the officer in plain and intelligible language. The site time and place
I want to see the language. Tell me again where it is.
is 87.015 subsection C. It's the requirements of the petition. The petition must set forth the grounds alleged for the removal of the officer in plain and intelligible language, and must cite the time and place of the occurrence of each act alleged as a ground for removal with as much certainty as the nature of the case permits. This, plus the provision of this statute that requires the court to conduct this proceeding insofar as possible in accordance with the rules of procedure in a civil case, dictate what our obligations are and what's really before the court at this time. The state certainly accepts and respects the court's recognition of the larger issues at stake here. But when you look at the way the statute seems to contemplate the proceedings to go, a petition is filed, no citation is issued, so there's no appearance made by anybody. So what does the court have to look at? The petition and what information goes with it. Presentation here today is, as Mr. Wilson said, a jury argument. It assumes that all evidence has been made, a determination has been made as to what is admissible and what's not. They would have you believe that whatever information we offered is to be disregarded and theirs to be accepted. That's not what we're about. That's not what we can do right now. What we can do right now is comply with this statute and with the rules of procedure and provide fair notice and a plain statement of what our contentions are. We believe we've done that.
Are you contending that I should look only at the allegations that you made in your second amended petition and not anything else? That sounds like what you're saying.
I'm saying that the procedure doesn't seem to contemplate anything else. I mean, how does somebody who's not made an appearance make an appearance? But that's really what I want to come back to, is if you accept the jury argument made by the defendant, it assumes that the ambit of all known facts has been established, and that all we're doing is arguing about what difference those facts should make. And we are a long way from that. We haven't done that yet. We believe that we're at a preliminary stage where we present sufficient information, legal authority, and a petition in plain language, and providing fair notice to justify service of this citation. Essentially what the defense is arguing is a general demur or a 12B6 motion, which is not provided for in Texas practice at all. And that's an issue that I think is what's specifically before the court today. Whether we can get to the next stage and determine what evidence is true and what evidence is not, and what should be done going forward towards a jury trial.
Okay, what else is anybody have? Got plenty of time now, and I want you all to say what's on your mind. I don't want a bunch of repetition of what we've already heard, but if there's something new or that would be helpful, I ask everybody on this side of the rail to stand up and talk.
Your Honor, I believe the state has presented everything we would like the court to consider in this matter.
There's no further questions, nothing further.
Anybody? I'm going to issue a ruling. Let me say a couple of things first. I want to commend the lawyers for the first-rate everything and arguments, and I appreciate it on all sides. I'm going to caution everybody in the courtroom. I'm going to rule, and then I'm going to walk off the bench. I don't want any audible reactions till I'm out of here. Okay. The citation that was previously issued by the district clerk is quashed. That's number one. Number two, the request that I issue an order requiring citation to be issued is denied, and the petition is dismissed. Thank you all very much.
All right.
Yeah, actually,
No, I know all about that.
I would have said we were.
Mr. Little,
It's a non-appealable matter. Thank you very much.
Mr. Wilson, Mr. Walker. Yes. Can I get, we have, I think those would be mine, David.
Yeah, that one's mine.
hey, I tried one day. Like this morning?
I had a trial with you once, young man. I'm trying to remember where the hell it was, because you kind of filled in, I think it was Beecher Benson one day. No, I tried to get some Shaw in here, trial. Hey, great guy. He kind of parachuted in a couple of days.
He's good at that.
Hey, Susan, you're going back to work. Glad you did it.
Hey, I follow orders.
They didn't even look worse. Sure you are. Steam and steam. Thank you very much.
I'm a hang the red. I went to junior college first.
Yeah,